I will repeat. Good morning, everybody. Good morning. Thank you very much. So welcome. Thank you very much for coming. My name is Bert Brandenburg. I am the Executive Director of Justice at Stake. We're a nonpartisan partnership of organizations working to keep courts fair and impartial. We have more than 50 groups who we count as partners, some of whom are represented here today. They include legal groups, good government groups, business groups, state groups of all stripes. Our ranks include Democrats and Republicans, liberals and conservatives, defense attorneys and plaintiffs' attorneys. Our honorary chair is former Supreme Court Justice Sandra Day O'Connor. Justice at Stake educates the public and promotes reforms that will protect the courts. We are here today to talk about the most important democracy issue flying under the radar of the American political scene, and that is whether our courts can remain fair and impartial and provide equal justice under law amid what has become a growing threat from special interests and partisans. And our framers created a constitutional system designed to insulate our courts of law from political pressure so that they could resolve disputes fairly and protect our rights, but that insulation is being worn away steadily a year at a time by a relentless campaign of big money spending and political bullying. Now, this threat to the courts has several facets. They include attempts to impeach judges over controversial decisions, efforts to defund courts or strip their jurisdiction in retaliation for individual rulings, the challenges that people of color and other minorities face in even getting onto the bench, and a relentless drumbeat of anti-judge, anti-court rhetoric pouring out from talk show hosts and pundits and anyone else who can pump up their ratings by attacking the courts. Our courts were not built to defend themselves in the political arena. That's why there's a justice at stake. And today we're going to focus on the most ominous of all these threats, what has become a precipitous arms race in fundraising and interest group spending in Supreme Court elections around the country. And we are here to mark the public release of this new report, The New Politics of Judicial Elections, 2011-2012, subtitled How New Waves of Special Interest Spending Raise the Stakes for Fair Courts. I want to thank profusely the co-authoring organizations, the Brennan Center for Justice and the National Institute for Money and State Politics, and even more profusely the individuals involved, including our lead author, Alicia Bannon, who we have here on the panel today, as well as Eric Velasco, Linda Casey, and Liana Reagan, as well as from our own staff, Laura Kinney and Peter Harden, who are the editors of this document. I also will take my prerogative and welcome no fewer than 3 of our board members who are here today with us. Justice Randy Shepard from Indiana, who will be one of our panelists, Tom Gottschalk with Kirkland & Ellis is here, as well as Mike Petro with the Committee for Economic Development. And I'll thank CED, as it's called as well, where Mike works, for their help in sponsoring this event. I also want to note that we're transmitting this event live via webcast. And I want to welcome those of you from around the country, who knows even farther, who are joining us today. There will be an opportunity, in addition to audience questions, for people on the web to ask questions, and we hope to really make this whole event as conversational as we can, both up here on the dais and including all of you. Before we begin, I would like to acknowledge the very special honored guests who've joined us today. In the center is Justice Marcia Turnus. She is a native of Iowa, and she was appointed to the Iowa Supreme Court in 1993. Her fellow justices then chose her to be Chief Justice. She was the first woman to ever serve in that position. And as chief, she encouraged court efforts to improve access to justice, support pro bono efforts. She worked to strengthen her court system's oversight of child welfare cases across the system. She currently serves as director of the Harkin Institute of Public Policy and Citizen Engagement at Drake University. She will be telling you about what happened in Iowa a few years ago, but she may not tell you this part of it, which is that because of her role in a unanimous Iowa Supreme Court decision legalizing same-sex marriage in Iowa, she and 2 of her colleagues were honored with the John F. Kennedy Profile and Courage Award last year, and we are honored that she has joined us. Justice Randy Shepard, all the way down at the end of the dais, is, as I mentioned, a Justice at Stake board member. He recently retired after a long time as Chief Justice of the Indiana Supreme Court. He had been originally appointed to the court in 1985 and was picked just 2 years later and became the nation's youngest state Chief Justice. He served as president of the National Conference of Chief Justices for a couple of years. As justice, he authored more than 800 majority opinions, published more than 40 law review articles. And I say this because this was in part how he came to our attention. One of the things we discovered when we began working on these issues more than a dozen years ago was that there was a Chief Justice who'd been out there sounding the alarm about judicial election issues even before we were in on this, and that was Randy Shepard. And we actually gave him an award up at Harvard Law School a few years ago for outstanding efforts on behalf of judicial outreach in defense of the courts. Last and certainly not least, I think we have a three-way tie here, is our lead author on the report, Alicia Bannon. Alicia serves as counsel for the Brennan Center's Democracy Program, where her work focuses on judicial selection and promoting fair and impartial courts. Before she joined the Brennan Center, she served as a John J. Gibbons Fellow in Public Interest and Constitutional Law, as well as an adjunct professor at Seton Hall Law School. And after graduating for Harvard and then Yale Law, she clerked for Judge Kimballwood and for a Second Circuit judge by the name of Sonia Sotomayor, who you may have heard of. So as we review the contents of today's report, I'm going to start by noting that 98% of all cases are decided in state court. They are the engine of our justice system, and their decisions affect everyone's lives. 85% of all state judges have to stand for election at some point during their career. So how we pick our judges is hugely important to how our democracy works and how our justice system works, because it can affect the quality of our bench, it can affect the political pressure that judges face once they're on the bench, and above all, it can affect whether our courts can stay fair and impartial. Judicial elections have been with us for more than 150 years. During that time, they've mostly been inexpensive, mostly been stable, and at least somewhat insulated from some of the political tides that have nothing to do with protecting people's rights or resolving disputes fairly. That has been changing. And since 2000, there's been a national arms race arising around our courts of law, and so we've seen spending over the last decade or more in state Supreme Court elections exploding, smashing records in states across the country. And in 2011 and 2012, as we detail in the report, we saw another huge haul. It's now become routine that judges are raising millions of dollars from parties who appear before them in court. And in addition, however, one of the really big stories that those of us who have been watching this for a while picked up on this time around is a culmination of a trend we've been seeing for a little while now, which is a surge in outside spending, by groups, not to the candidates themselves. And so we saw special interest groups and political parties spend a record $24.1 million. That's 43% of the total in state judicial election claims all last year. Just by way of comparison, 4 years ago, outside groups and political parties spent 22% of the total. 4 years before that, 16%. This has been a huge rise. And the big four states that we saw the spending come into were Michigan, Wisconsin, Florida, and North Carolina. What these states have in common, as is often typically the case where the spending goes on, is that they were highest on divided courts, where there might be some kind of ideological balance in the play. Whenever we see a sort of composition of the court contest coming up or direction of the court contest, we look hard to see whether the money is going to start pouring in. So why is all the money coming in? Basically, since 2000, what we believe has been happening is that the tort wars are becoming court wars. And so we see businesses and their allies locked into this arms race with plaintiffs' attorneys and their allies. And why are we seeing the more recent surge in outside money? Here, I'm not sure I have the definitive answer. Maybe we can speculate on that today. I would note that this is the first full election cycle that we had tracked since the Citizens United case came out of the Supreme Court and its effects in terms of helping change the landscape for political spending, opening floodgates for spending by outside groups whose no-limits arms race is changing other parts of American politics and may well be overrunning judicial races as well. And so who are the outside actors? They come from all sides. So we see conservative groups such as the Koch brothers, Americans for Prosperity, the Judicial Crisis Network, which is based here in D.C., the Law Enforcement Alliance, which is linked to the NRA. Groups on the left include America Votes, Human Rights Campaign, and the NEA. We can identify some of these brand names, but we don't often enough know what the real source was. Because of weak transparency laws, these numbers are often opaque or even concealed entirely, and in part because Citizens United, again, encouraged some of the spending that is amongst the least transparent within the political system. And as a result, we see lots of new groups playing in judicial elections with names like the North Carolina Judicial Coalition and Citizens for a Strong America, but discovering the donors' donors, the real check writers, can often be impossible. So we also see another interesting movement that again is rising within this field towards outside spending becoming concentrated in fewer and fewer hands, or fewer and fewer checks, I guess you might say. The top 10 spenders in the last cycle accounted for 35% of all Supreme Court spending. That's a share that has been rising. Some years ago, we noted when an Ohio labor leader cracked that it's a lot cheaper to buy a state court than it is to buy a state legislature. And these are interest groups that see our courts as ripe for the buying. And in terms of what we know about who those super spenders are, it's interesting to look at the chart here. The top two came out of Michigan because that was the most expensive race we saw last year, and so we saw the state parties. If you go further down, you'll then see lots of those groups with the generic names that don't really give voters much information about where the money's coming from. And so, for example, on the one hand, if you take the money spent by the North Carolina Judicial Coalition, which is there fourth on the list, you're going to find that money came to it from State Chamber of Commerce, State Republican Party. You can trace it farther back and ultimately get to Washington, D.C. and the U.S. Chamber of Commerce as well. On the left, you'll find that the Greater Wisconsin Committee, whose donor base is actually impossible to penetrate, is nonetheless affiliated with groups that receive support from labor unions. So, what effect is this having on our justice system and public confidence in the courts? This very morning, we are releasing a brand new poll that Justice at Stake and the Brennan Center commissioned. It was conducted just last week, and it showed that 87% of voters say they believe that campaign contributions are having an impact on courtroom decisions. And so, in other words, a vast majority of Americans now fears that justice is for sale. We've actually tested this question for years using a variety of pollsters. We come up with rather consistent results, and what we can say now is that this fear is rising. These numbers used to be lower, and it has reached a record level. It's also worth noting that when we asked this same question of the state judges themselves some years ago, a chilling number of nearly 50% came back with that same answer, that they thought that campaign cash was affecting courtroom decisions. I'll mention as well that the same poll found that 87% of voters agreed with the same statement in regard to independent spending. So we asked it both with regard to campaign contributions to the candidate as well as to independent expenditures. The public fears that the money has the same impact either way. We also asked about recusal, which is one of the more common reforms, and Alicia's going to be talking about the reforms. I'll just note, since we're talking about the polling, that we saw a very large number of Americans believe that if the campaign, that if one party in a court case has contributed heavily to the campaign of a judge hearing the case, that judge should really consider stepping aside. And here, too, as well, the voters made no distinction when we asked the same question about independent expenditures. They worry that it has the same possible effect. What we have been calling for a number of years the new politics of judicial elections is more than just an arms race. It's not just one more story of money pouring into politics. It is all those things, but the surge in money and political pressure on our courts of law is becoming a literal threat to our constitutional system. Our courts are supposed to be accountable to the law and the Constitution, not partisans and special interests. They're supposed to protect our rights, not their donors' interests. And too many judges now feel trapped in a system they didn't sign up for, dialing for dollars from parties who appear before them and looking over their shoulders at groups who spend millions to intimidate them into ruling their way. Too many business leaders feel compelled to spend millions trying to buy influence instead of creating jobs. I also fear that the money chase has grown up around judicial elections in a way that may start to drive away many of our brightest and most impartial attorneys and law students from even considering a career on the bench in the first place. We need a court system that's run by people who want to be judges, not politicians. But if the trends we're discussing today continue to get worse, many of our best would-be judges, I fear, will step aside and sit out, and the spiral will accelerate even further. And so we're here today to spread the word. We want to tell the story of what happens when money floods into our courts of law, what it looks like from the inside, and what can be done to keep our courts fair and impartial. With that introduction to the issue, I want to thank you again for coming today. I'm pleased to turn the dais over to Alicia, the lead author of today's report, who along with the other co-authors, have just really done a tremendous job on this report. I just want to personally thank them all, and Alicia in particular. She's going to talk about what the money's buying, what can be done, and then our distinguished jurists are going to talk about the view from the inside. We want this to be as interactive as possible. We're going to have some conversation up here. We want to get you in on that if we make this a conversation as we go forward. So Alicia, we'll take it from here.
Thank you, everyone. One of the main findings of our report is that television is increasingly where Supreme Court election battles are getting fought. We saw unprecedented levels of television spending in this most recent 2011 to 2012 cycle, more than $33 million over those past 2 years, and which, as you can see, is significantly higher than what we've been seeing in past years. Beyond the spending itself, we also saw that mudslinging has really become the new normal in states around the country. We documented at least 10 states where negative ads aired, and this is a troubling trend for several reasons. First, it blurs the lines even further between politics and judging. As Bert noted in some of the polling results that we just released today, I think one thing that's very clear is that the Americans don't want judges to be politicians in robes. And what happens when you see this proliferation of attack ads is, it helps create a carnival atmosphere around judicial elections, and it further hurts public confidence in our courts and in our judges. The ads are also frequently misleading. So what we see are ads that misrepresent the backgrounds and records of the judges that are standing for election. And in elections that are already very low information, introducing more misinformation hurts public understanding of what courts do, and again, hurts public confidence in our courts, and undermines the ability of voters to make informed decisions about the judges that are standing for election. We also found that frequently ads are focusing on the decisions that judges make, putting judges effectively on notice that when you make unpopular decisions, when you make controversial decisions, you're putting yourself at risk of potentially being the subject of millions of dollars of attack ads, focusing and often distorting your record. And I'm sure that that's something that we'll talk with our panelists about when we move to our discussion, particularly because one of the states that we document in our report where this happened was in Iowa. So I wanted to, rather than just talk about this, actually show some examples of some of the attack ads that we documented in our report. So I'm going to start with a video clip coming out of the Michigan Supreme Court election in 2012, and then also show some other examples, screenshots of some other ads that we've seen. So this first one will be Michigan.
June 16th, 2010, the day our life was shattered. My son Joe was taken from me, killed when his unit was attacked by terrorists in Afghanistan. My son selflessly gave his life for this country. So when I heard Bridget McCormick volunteered to represent and help free suspected terrorists, I couldn't believe it. My son's a hero and fought to protect us. Bridget McCormick volunteered to help free a terrorist. How could you?
Sorry, do you have audio? That was an ad that came out of the Judicial Crisis Network, a DC-based organization. They spent, we estimate, somewhere between $600,000 and $1 million to publish that ad. It featured, as you saw, the mother of a Michigan soldier that was killed in Afghanistan, and referred to Justice McCormick's involvement as a volunteer co-counsel for Guantanamo Bay detainee. In fact, the detainee was actually transferred for prosecution in Tajikistan, where he is currently serving a 17-year term. The next ad, and I'm not going to show clips for every single one, but the next ad I wanted to focus on was one that came out of Ohio, also in the 2012 race. In this ad, one of the candidates, Bill O'Neill, was accused of, quote, expressing sympathy for rapists. This was another ad that it focused on a decision that Justice O'Neill made as a judge. It was an ineffective assistance of counsel case involving a rape case, and as part of his decision, he spoke about the seriousness of a rape accusation and the implications of a rape conviction, and that those words were distorted into an ad accusing him of expressing sympathy for rapists. In fact, the Ohio State Bar Association described the ad as misleading and stated that it, quote, impugns the integrity both of a candidate and of the court, and implies that justice is for sale. And in this ad as well, it came from the Ohio Republican Party, which spent about $100,000 on the ad. Another ad I wanted to highlight came out of Wisconsin in 2012. This came from the progressive group, the Greater Wisconsin Committee, that spent about $500,000. This was an ad opposing Justice David Prosser, focusing on his record as a district attorney, and specifically a 30-year-old case which they characterized as an example where, as a prosecutor, he failed to prosecute a child molestation case, swept it under the rug. Again, this ad was widely condemned by people within the state, including by the victim in the case, which labeled the ad as, quote, offensive and inaccurate, and called for it to be removed. In fact, they declined to remove that ad, and so it continued to show throughout the lead up to the Wisconsin election. And finally, I'm going to show one more clip. This comes out of the Kentucky 2012 race.
Lee Parrish and Roger Wheeler were sentenced to death for ruthlessly murdering pregnant women. But former Justice Janet Stumbo voted to reverse both convictions. Not one of the other 6 justices agreed with Janet Stumbo when she wrote, "The trial courts erred, allowing the juries to hear evidence that the victims were pregnant." Former Justice Janet Stumbo sided with criminals 59% of the time. For fairness, re-elect Will T. Scott, Supreme Court Justice.
So this was another ad coming out, as I said, of Kentucky in 2012. This ad was actually sponsored by Janet Stumbo's opponent. I think it illustrates a lot of the dimensions that I was just talking about. It has a racial dimension. I think it's a Willie Horton style ad, but it also focuses on Justice Stumbo's record when she was a Supreme Court justice. In fact, distorts that record and puts judges on notice. I think particularly in criminal cases that you are at risk when you make unpopular decisions, when you side with criminal defendants, when you and in other cases take controversial positions, that your record can potentially then be made a campaign issue and used against you. So who's responsible for these ads? We also did a study of who was actually sponsoring the ads that we documented. And one of the findings that I thought was very striking was that outside groups, special interest groups, were much more likely than candidates to go negative. And so I think this is one reason to be very concerned about the trend that Bert spoke about that we documented in our report about the rise of special interest groups directly spending on television ads rather than contributing to candidates and trying to impact elections that way. Because what we've seen is that when special interest groups are directly spending on television, they're much more likely to go negative than candidates. And so what we worry about is that this is, not only are we seeing an arms race in terms of spending, but we also risk now seeing a race to the bottom in terms of television advertisements, where special interest groups are more and more likely to start pouring money into directly buying ads, and that the ads that we're going to start seeing are going to become more and more negative. And I don't think it's a coincidence that of the 4 ads that I just showed, 3 of them came from special interest groups or political parties. So where do we go from here? I'm hoping that that's part of what we'll talk about with our panelists as well, but I wanted to flag some of the reform measures that we also highlight in the report. The basic takeaway in our report is that the public needs to be confident that our courts are not for sale. One thing that we highlight as important is the need for disclosure law reform, so the public can know where the money is coming from and who is spending money trying to influence who gets selected for our courts and the decisions that they make. We also want to see recusal reform so that judges are required to step aside from cases where major donors to their campaigns or major spenders in support of their campaigns are actually appearing before them. We also want to see public financing of judicial elections. Public financing is a vital reform because what it does is give candidates the opportunity to run competitive races without needing to rely on special interest dollars. And in addition to these reform measures, another thing that we talk about in our report is forms of judicial selection. Historically, merit selection, a system whereby judges are first vetted by a judicial nominating commission before being nominated by a judge, and then typically stand for an up or down retention race after a period of time. Historically, those have been lower cost races and less politicized races. In recent years, starting in 2010 and then continuing and expanding in 2012, 2012, we've started to see money start pouring into retention races as well, but the fact still remains that those races on the whole have been less politicized and lower cost than competitive elections. With that, I want to turn things over and start our conversation with our panelists as well. I did want to mention, for those that are interested in the advertisements, our website, newpoliticsreport.org, actually has an ad page where you can do searches and look for, you can see any of the ads that we talk about in the report, and you can do various queries to find attack ads coming from particular states. And that website can also be linked to from the Brennan Center website, as well as the Justice at Stake website. So with that, I'll turn things back to our panelists.
Thank you so much, Alicia. And as Alicia said, I think what we should do now is just turn to our panelists, and maybe Justice Turnus first. We said we wanted this to be fairly conversational. Maybe you could just start by telling us the story of Iowa, what happened a few years ago, what you saw from the inside about the trends we're describing from the outside.
Okay. Well, first of all, let me thank you for having me here, and also for your continuing efforts to focus on the politicization of the judiciary. I agree with the statement made earlier that it is literally a threat to our constitutional system because of the deterioration of the confidence in the courts that we see occurring. Iowa is an example of a retention election in 2010 that was very politicized. A year before, the Iowa Supreme Court had issued a unanimous decision in Varnum versus Breen, concluding that the Iowa statute limiting marriage to one man and one woman violated Iowa's equality clause because it denied over 200 privileges and benefits to same-sex couples that were accorded to man-woman marriages. There was a lot of controversy surrounding the issuance of that decision, and I think we were probably quite aware that there might be some kickback come election time. There were 3 of us on the retention ballot about 18 months later in November of 2010. And leading up to that election, there were a lot of special interest groups who came in from outside of Iowa who launched a campaign against the 3 of us on the retention ballot. These groups formed an Iowa program. It wasn't an Iowa entity, called Iowa for Freedom. So when you talk about not knowing who's behind things, it can really be garbled when they actually use a name that I think was fairly misleading, because it really wasn't an Iowa group funded by Iowa donors. It was all out-of-state money. They focused, you would think, because the motivation of these groups was directed toward the same-sex marriage issue, that would have been the focus of their efforts against us. But they actually expanded their message, I think, to encompass as many people as possible to vote against us by packaging the same-sex, or using the same-sex marriage decision as just an example of what happens with, they like to call us elitist judges, an arrogant judiciary, an activist judiciary, activist judges, noting that if courts can do this with respect to marriage, none of your freedoms and liberties are safe. And they would mention immigration, gun control, eminent domain, education. I mean, anything you can think of that any member of the public might be interested in was included in these ads. They did a lot of TV advertising. They would say things like I was just saying, and the screen would show the American flag and Boy Scouts and hunters and those kind of things. So I think that the efforts in Iowa were very much focused on fear and anger over created by labeling us in these attack ads. We did not, the 3 of us did not form campaign committees to advocate our retention. And there were several reasons for that. First of all, talk about judges who didn't sign up for it. I mean, we didn't sign up to be politicians and have to be out there raising money and campaigning. And I think the three of us were very uncomfortable even thinking about putting ourselves in that role. In addition to that, we felt that we would be contributing to the politicization of the judiciary by acting like politicians. And we didn't want to do that. We knew it put us more at risk, but we just felt on principle that if we didn't want the judiciary politicized, we certainly shouldn't be acting like politicians, raising money and going out on the campaign trail. We also didn't want the problems that come with raising money, and that is the recusals and the suspicions that the public have that you are being influenced by campaign contributions. And then there was a very pragmatic reason we didn't do anything. The Bar Association, the Board of Governors of the Bar Association, very strongly indicated they didn't want us to be out there raising money and campaigning, and that they would take care of things. Unfortunately, they actually didn't come through on that until the very last minute. The groups who opposed our retention spent over $1 million, and I think in the last tally there was maybe $400,000 raised that was used to do some robocalling. There wasn't any TV advertising in support of our retention. I don't know, is there anything else you wanted me to cover at this point? I could contrast it to what happened in 2012. One of the 7 members of our court was on the ballot a year ago in 2012. And the same groups came back to Iowa, but spent much less money. I think, and you might correct me, was it around $400,000 or $450,000? And this time, the groups in support of retention organized early, organized well, raised money, and had their own efforts to inform the public about the retention vote. So in 2012, the efforts to unseat Justice Wiggins were not successful, and he was retained. I want to just share one last little view from the inside to illustrate the impact when judicial elections are politicized. I was on the Iowa Supreme Court for 17 years, and I don't recall any time in any pleading filed with our court that the integrity of the institution or of the individual justices was ever questioned, even indirectly. And I don't ever remember hearing, grumblings from anyone that the integrity of the court was questioned. In fact, I think we probably had a fairly strong reputation for integrity. I served on the court for 2 months after the retention election, before my term ended. And in those 2 months, there were 2 pleadings filed. We have a process where a party who has lost in the Supreme Court can file a petition for rehearing, asking us to look at it again. There were 2 of those filed where the attorneys point blank said, well, you only made that decision because you were afraid of whatever, directly accusing the court of making the decision for political reasons. And I don't think that even would have crossed anybody's mind, let alone attorneys having the gall to actually put it into print. And those are 2 things I saw before I even left the court. I think the politicization of these elections are dangerous, even when the groups attacking judges aren't successful, because they leave a legacy of suspicion, fear, and the last thing I'm probably running out of my 10 minutes, but the last thing I want to talk about is intimidation. The groups who came into Iowa knew that they weren't going to change the same-sex marriage decision by getting rid of the 3 of us who participated in that decision. Their stated purpose on their website was to send a message across the nation that judges ignore, well, actually they called us the ruling class. The ruling class ignores the people at their peril. They wanted to make sure that what happened in Iowa stopped in Iowa, and that judges in other courts would think twice before they did what we did. And that kind of intimidation, I think, is happening across the country. It doesn't even have to be a hot-button topic. Issuing a decision in favor of any criminal defendant can be used against you later. And there are no advocates for the rights of criminal defendants. And their justice is really at stake by what's happening here, because judges are definitely intimidated. I'm not saying that judges change the decision they render, but it's naive to think that those kind of thoughts don't cross judges' minds when these kinds of decisions come before them. And that's a terrible way to operate a court system that's a foundation of our democracy. And I could go on and on and on, as you can tell, but I'll stop.
Well, let me ask you, Justice Turnus, have you or any of the other two justices who decided not to campaign last time had any second thoughts about that decision?
No, I don't think we do. No. It was one of those, it was the right decision when we made it. And I don't know how effective we would have been as campaigners and fundraisers, honestly. It just wasn't a skill set that anybody in Iowa had. And in defense of the people who supported us, they weren't used to having to mount this kind of campaign. I think, I'm not sure it would have made a difference, but I don't regret that. It would have been a miserable thing to have to do. And I think it was bad for the court that we lost our jobs. I really do. It did send a much more effective message of intimidation, because we were not successful in retaining our positions. But honestly, I don't really regret what we decided.
You know, there was another ripple effect that went forward from that race, in addition to the intimidation effect, which is the fundraising effect. And we saw, for example, one cycle later in Florida, justices who felt that they were being lined up to be the next Iowa, and they felt like they heard the signals coming. And what they did was that they went out and raised money like gangbusters. And,
well, you're right. And actually, there were a lot of people in Florida who contacted the three of us because they could see what was happening, and we did have conversations with them, and they were very much ahead of the curve, and they were successful in retaining their positions.
You know, and yet, you know, perhaps that's a success, obviously, for them, and you know, perhaps for the system, but of course, it's a rather Pyrrhic victory, even if you think it's a success, because what it meant is that more justices had to spend more of their time going out there and raising boatloads of money before they even stood for election.
And it does contribute to that statistic in the minds of the public, thinking that campaign contributions make a difference in judicial decision-making whenever judges have to go out and raise money.
Yeah.
And do you think that there's been a long-term consequence in terms of public confidence in the courts in Iowa?
Yes, I do.
So, Justice Shepard, you, as I mentioned before, you have been following this issue for quite a while. You've also seen some of it from the inside. You've also had the perspective of talking to a lot of your brethren around the country about this issue who faced it firsthand. I'd be curious what story you would have to tell as you hear about all this that we're describing here today.
First I'd like to say the people of Iowa lost a phenomenally good Chief Justice because I watched her at work, and we're all the poorer as a result of that, that turn of events. I'd like to muse, since you've asked me sort of an open-ended question about some of the frequent solutions and causes. One thing that I've concluded over time is that the issues on which judicial races are joined are more often than not the thing that is actually at stake. I can think of a few elections in which criminal law was what was actually going on. One in Nebraska, one in California, where the repeated votes of the judges in question painted I think, a fair picture, and the public decided they didn't like what they saw. And but those I think were the exception that proves the rule. The criminal cases are the easiest to characterize. they're the ones people read about in the newspaper each day. But more often, what's really going on is either a plaintiff personal injury versus insurance and corporations a kind of dispute, or an effort at turnout. I think there are a couple of primary races or prominent races in which what was really happening was an effort to affect who marched to the polls, not because they were interested in judges, but because the people who launched the campaigns around the judges figured that those voters at the margin would vote the way they wanted them to, either for president or governor or senator, U.S. representative. And I think this was especially true in the early 2000s. The 2004 election, I think, might have been the high watermark where that was true. So in that sense, the judges are often just roadkill for other kinds of activities that people are trying to advance in the political system. In terms, let me just say two things about solutions. One is that I think we ought to reevaluate the place where the country has gone, and indeed where judges now find ourselves. The basic decision from the mid-1970s through the 1990s was to keep money away from candidates and political parties. This starts with Fred Wertheimer and the post-Watergate statutes, continues through McCain-Feingold, and makes it progressively more difficult for people to contribute to candidates to raise money, political parties to raise money. And the result of that, of course, has been that the money finds whatever crevice it can and flows into groups which are less transparent and less accountable. One of the great things about American political parties has been the party as mediator. The parties are big enough so that they have under their wing all sorts of interests, not all of whom always agree with each other. But you know where the party got its money, you know who the chair of the party is, you know who the central committee or the state committee is, and there's a kind of responsibility that flows from being the person who has to say his or her name as party treasurer down at the bottom of the ad. Same is true with candidate committees. And when I first knew about campaigns, most of the money that got spent either got spent by candidate committees or party committees. That's no longer the case in these kinds of races, and I think that's been a mistake, and that the notion that we ought to suppress the parties and the candidates as fundraisers, both in general elections and in judicial elections, causes the money to flow into places where only single issues or partial issues are the thing which the group is advancing, and where the disclosure isn't and is unlikely to be anything like what we get out of political parties. So there's a rather large policy decision that I think in which I think country's taken the wrong turn, and I think it shows up in these judicial elections in a way that's very vivid. A few words about the disqualification problem. As you might know, there's an ongoing argument inside the American Bar Association, which is the first place that model codes are written on these matters, and the tug-of-war is between the traditional ethics elements, the standing committees that work on ethics in the ABA, and the judges, the judicial division and others. One of the problems with a robust disqualification rule is that at the end of the day it turns the election into a fraud. It is to say, you send out candidates, either parties or interest groups, and you say, don't vote for Shepard, vote for Turnus. because you'll get the following result if you vote for Turnus. You won't get it if you vote for Shepard. If the disqualification rule is, and so the public says, oh, that's right, that's the way I'd like the courts to go, I'll vote for Turnus. And then it comes time to make good on this decision that the public has made, and Turnus disqualifies and says, well, that is really the way I would do it, but I'm not going to do it today because of all the money spent electing me to do it. There's a real tension there. If you say to the voters, you've got a thing to do here. This, by the way, applies to presidents of the United States, not just to elections. Makes a difference on whether we elect John McCain or Barack Obama and what kind of federal judges we get. But it applies in the setting we're now discussing, in which you have to decide, does the public have a role here, yes or no? And if they do, how do you account for the money problem without making their trip to the polls an illusion that they do not understand? So I think that element of the task is a lot trickier than we tend to give it, than we tend to credit it. Finally, very interesting to hear my friend Chief Justice Turnus talk about the decisions that she and her colleagues made and the one that Justice Wiggins made, because as we know, one of the things about 2012 was that those who were targeted, not just in Iowa but elsewhere, decided to fight back, not only on individual campaigns but on the various efforts to weaken or abolish merit selection systems. And I think without exception, the public, having received enough money spent on both sides to understand the issue, said, we don't want any part of this. Florida, Iowa, Missouri, and a bunch of other places where the voters said, now that we've had this debate, we'd rather have less political courts than more political courts.
That's fascinating. I'd love to talk with you a bit more about the points you were raising about disqualification rules and the debate, as you mentioned, going on in the ABA right now about exactly how those rules should be structured. And I was just curious if you think there's a distinction between money being spent discussing particular issues and then having, and then those issues appearing before judges, and then money being spent by litigants when those litigants themselves are then appearing before the judges. And I know that's something that Bert mentioned in our recent poll. There's wide agreement in the public, at least, that they see concern when a litigant is actually spending money and then appearing before a judge. And I'm wondering if you're concerned by that distinction or no.
No, I think that is a legitimate, in the sense that you would analyze it in different ways. We spent several $100,000 at least in a case called Right to Life versus Shepard, defending Indiana's canons on commitment to positions, commitments to issues that might come in front of the courts. And the good news is that we prevailed. We didn't just prevail, we prevailed under the pen of Frank Easterbrook, who said this looks like a good arrangement to us, certainly not an unconstitutional arrangement. But that was the sort of the final moment, or maybe the penultimate moment in a series of cases where most judicial canons had fallen on the pens of judges. I can't blame anybody else for the way that turned out. I do think there's a distinction between the issues and the contributions. The real tricky part is what does the limit look like? Are you looking only for contributions to me or freestanding contributions? There are a lot of tricky questions there. How big is the jurisdiction? The limit has to be different depending on how big the jurisdiction is. That's not particularly difficult. Just to list one of the things that's in play, for several decades at least, the model ethical rules for these matters said what we wanted to do was to keep the judge from knowing who contributed, on the theory that that would be a bad idea. One recent iteration said we want the judge to go find out who contributed to her and tell the parties. And quite a very different idea about how you built a sense of impartiality and confidence in the voters. So I think we're not quite there yet on how many of those would work, but I agree with the general thrust of your question.
Justice Turnus, I'm curious, do you, as you've heard Justice Shepard talk, is there anything that sort of occurs to you with the points he made in terms of reaction on recusal or the other issues?
I'm sorry, Shepard covered too much ground.
You know, well, my initial reaction when I hear people discuss recusal is that it indicates that there's some problem that's trying to be solved. And I personally think it's more important to focus on the root of the problem and not necessarily how to take care of it. Recusal rules are good, but the system that requires recusal rules then results in decision-making by a court that's handicapped because not everybody is participating. What I'd like to throw out is that I think this discussion about judicial elections has to begin with the question, at least from the perspective of a court of last resort, of what do we expect, how do we expect courts of last resort to operate? How do we expect them to make decisions? I think if you look at the ABA standards, the vision of a court of last resort is that they will act in a manner that allows them to reach a collective decision so that the diverse perspectives and wisdom are brought to bear on each issue, and the resulting decision is better than a sum of its parts, that there's a synergy that comes with collective decision making. But when we politicize courts so that people are elected because they will vote a certain way or because they will adhere to a particular ideology, we create courts that are composed of people who come with preordained votes or preordained positions to defend. And the discussion becomes quite different in a court that's composed of justices who were chosen because they do espouse a particular position, whether it's on criminal justice or same-sex marriage. There is not that synergy of decision-making and the collective discussion at least in as free a manner that could occur if elections were not politicized. I think by politicizing the courts, we are changing courts from this collection of, or this, the ability to bring diverse perspectives, diverse viewpoints on a continuum range to bear on a decision so that a collective decision can be made. And we're changing them into mini legislatures where you come in and the 4 Republicans vote one way and the 3 Democrats vote another way. And I don't see how that's the rule of law, because that law changes when you can flip the majority from Democrat to Republican. So I think all of these issues have to first look at what kind of court do we want, because you get what you ask for. And if you're going to politicize courts, then you're going to politicize judicial elections, then you're going to get politicized courts. Thank
you. So before we open this up to questions from the audience and discussion and from people viewing this on the web as well, I want to sort of add an observation to the discussion we've got going here on recusal, which I think has been a very good one, and some very subtle points are being made here. I think, you know, to some extent, on behalf of a lot of us who have worked on recusal reform issues and urged certain things over the years, many of us were toiling in the vineyards on the very sort of what I would call front-end reforms that you describe as the preferable way to approach these issues. And amongst our experiences were that those are pretty hard to enact. If anything, they may be getting harder these days, given where certain legislatures are. Some of the reforms that Alicia talked about have actually been enacted and then repealed by people who want more interest group influence over the courts. The recusal issue arose, I think, in some ways for 2 reasons. One, there was this big ticket case. Caperton comes up in the Supreme Court, a West Virginia case where, a single energy company executive spends $3 million to put a justice in who then overturns a $50 million verdict against that energy company, that the U.S. Supreme Court said that justice did have to step aside. That was extreme enough. I think everybody on all sides of the recusal issue agrees it should be something of a last resort. And in fact, I personally view it as a safety net. It's there if the other reforms aren't there or simply are not working, but nowadays there seems to need to be a safety net. And so when one talks about the trade-offs, and again, I think some very subtle points are being made here about risks of trade-offs, they are real, and yet I think they have to be weighed against something that's actually changing in this debate, which is the amount of money, which continues to go up and up, and where the money is coming from. I doubt that any of us have the perfect reform. We all sort of work hard at them. But the landscape of the debate is changing as we speak. And I think the other observation to note with recusal is that when Caperton was decided and there was something more of an actual debate with a lot of good points made on both sides about recusal, there was the dissent by Justice Roberts listed, I think, something like 70 to 90 sort of, risks of this decision. And amongst them was that there'd be a flood of litigation, flood of recusal motions, and that there would be more cases and more justices sort of being taken out, and this risk of, as the justice puts it, almost like a fraud on the voters. From what we can tell, that hasn't happened. It's now been several years since Caperton. We don't believe we've seen any evidence of a flood of recusal motions. We don't see evidence of kind of, electoral attempts to kneecap justices by using recusal and it turning into a fraud for the voters. These are real concerns, and they should be taken in consideration, but it's such a dynamic debate is what's fascinating about it. I mean, we're debating something where the terms are shifting under our feet, which is hard on a good day. And when you add all the money in, it makes it even more challenging. With that said, we now have some time for questions and thoughts from the audience, and we'll ask for some from the web as well. We'll ask people as they are recognized. We have a microphone for you. Please wait for that. If you can identify yourself and sort of what affiliation brings you here, that'd be great as well.
Good morning. Tom Gottschalk, member of the Board of Justice at Stake. And going back to Justice Shepard's comments, I was reminded when his third point was that people got organized, spent money, and won retention races, that Justice Breyer's frequent comment is the only answer to money in politics is more money, in the sense that money is speech. And if you're going to counter speech on one side, you've got to raise money and have more speech. Which then goes to Justice Shepard's first point, and I'm wondering, Justice Turnus and the rest of the panel, how you feel about the notion of taking the caps off party expenditures, as the Supreme Court may do anyway. But one of the ramifications of what he's suggesting is that if the parties actually had more money and could control that in primary races or otherwise, you might get much greater transparency. You might even get better candidates in the end, and less of this special interest manipulation. So I'm wondering, Justice Shepard may disagree that the answer here is to take the caps off the organized party candidates, but I'm wondering how the rest of you feel about this problem in terms of how are you going to counter the effect of third parties working indirectly. Would you agree with Justice Shepard that having the parties play more role and perhaps spending more cash would be an answer?
I don't think it would have made any difference in Iowa, because the special interest had a very special interest in sending a message by getting us off the court. And I certainly don't have the historical knowledge that Randy has to say whether, it would make a difference. He may be right. But I know I'm a broken record on this, but I still come back to the point, you can make all those changes. You can do anything you want about recusal or who's going to contribute to campaigns, but they all lead to the same result. The courts are still going to be politicized.
And just to add to that point, I would say that I would have serious concerns about taking the caps off, because I think we would see even more of an arms race than we've seen to date. I think political parties, for example, are tremendously effective already at channeling and funneling special interest dollars, and I don't think that we want to further eliminate the few campaign finance protections that we may already have. I mean, I'll note that in a number of states, don't have very strong campaign finance protections to begin with. And so some of the debates that we're seeing on the federal level in terms of, the scope of campaign finance reform and the impact of, recent decisions weakening campaign finance reform, in many cases, we are already seeing that impact in states around the country where, since 2000, we've seen an arms race in spending. And I think for many of the reasons that Bert spoke about initially, that's not a situation that we want to further encourage. The money pouring in creates potential conflicts of interest for judges. It leads to this carnival atmosphere that we've seen in races with negative attack ads and other amounts of television spending where judges start looking more and more like politicians. I think what we should be doing is thinking about measures where we can start making judges look less like politicians. So I think recusal reform is one area, and I think there's a really interesting conversation here about how exactly it should be structured. But overwhelmingly, the American public is very uncomfortable with judges hearing cases in which campaign contributors or individuals that have spent significant amounts of money on a campaign are then appearing before those judges. I think to the transparency issue, we need much stronger disclosure rules. I think one of the big concerns that we document in the report is that in many states, you have millions of dollars of spending and nobody knows where that money is coming from. In Michigan, there was over $10 million of spending on television ads, none of which was reported to campaign finance authorities. And so I think on a number of different dimensions, there's specific policy measures that we can take to start reining in this politicization of judicial elections.
Question back there.
Excuse me. Sorry. I'm Caitlin Polance. I'm from the PBS NewsHour, and I'm listening and hearing you say that the problem that you're identifying is that there's the politicization of judicial elections. Wouldn't that be the predictable outcome of having elections to begin with instead of appointed positions? And is there anyone looking at that sort of situation? Is there spending trying to get, trying to change the process?
To the north, Minnesota has an active effort underway to depoliticize their appointment process. And I don't really have the specifics. Maybe somebody here at the table does. So those efforts are out there, and one would hope that as these judicial retention elections escalate in terms of attack ads and just generally making judges out to be politicians, that the public would get sick of it and think, we don't need judges to be politicians, and maybe look at efforts to change the way Minnesota is.
Politically, when one looks at the list of reforms that we're discussing that Alicia listed, there has been a reaction to what's going on. And as I said at the beginning, our organization, Justice at Stake, was helped to lead some of these efforts. We work with reformers around the country who are very worried about these trends we're discussing, who want to do something. They sometimes have different menus of options they think will work best in their states. One of the ones that, as Justice Turnus said, is being thought about seriously in Minnesota is to move from a contested election system where one candidate faces another, and this is where the vast majority of the money has come into these races, to what Alicia talked about as a merit selection system, where you have a screening commission, it should be nonpartisan and have lawyers and non-lawyers come up with a slate of candidates that the governor can pick from. That person then goes on the bench, stands for periodic retention election by themselves. Now, that's the kind of system that both justices here at the table have come up through, and obviously it didn't work out so well in the case of Justice Turnus's election. The money still came in, but when we look in the long haul, the aggregate amount that's come into those races is far, far less. So this is the reason that the Minnesotans and a number of other people around the country are looking at this as a prime example. There is obviously no perfect way to pick judges. There can't be. And in terms of the reforms, they're often a Rubik's Cube. You do one thing and something else happens. To the degree that you try to focus most of all on what system is going to give you the incentive to keep your courts fair and impartial, some clarity can start to come in terms of your political culture, but it may be that public financing works best in a state. We saw in North Carolina, where it was adopted 10 years ago, it worked like a charm. The judges all signed up. They love the idea of talking to donors, talking to voters instead of donors. That was the whole point. And yet, to the degree that there's been a reaction to all this, there's been a counter-reaction. And so as these efforts are made, often a lot of the groups who are trying to have influence are spending money on the other side. So there actually is something of a rich political story happening in this regard. It's happening state at a time. It defies explanation in terms of an easy national trend, but it is active in a number of states. A lot of people are very concerned, often bar associations, but also groups like Leagues of Women Voters and other civic groups. And our ranks include, as I was mentioning before, business groups and trial attorneys. We find that there are people on all sides of this spectrum, including people who play in these elections. And they want to win by day, but they are worried about what's happening to the system. And part of our goal in publicizing this information is just raise the tide of concern so that enough people will want to step forward and do something about it.
And I think also if you look historically at the rise of judicial elections, the concern was that you wanted to create public accountability, but it was accountability towards the law and the Constitution, so making sure that you had judges that were following the law, that were qualified, and seeing elections as a way to hold judges accountable in that context. Unfortunately, what we've been seeing, particularly over the last decade or so, is increasingly judges being instead held accountable to special interests. So as that special interest money has poured into races, you've seen the distortion of judges' records. You've seen judges being retaliated against for decisions that they've made. And we've really seen these races transforming into something much more political and much more troubling.
The question of how you choose judges is one of the great hobbies of the American experiment in government. And I think the choices should be seen along a continuum that alters the relative level of involvement by voters, by interest groups, by other political officials, and I'd be the first to say that none of them is perfect. That's why we keep arguing about it in our country. But on one end of that spectrum are methods like appointment and confirmation, or merit retention, screened appointment by governors with retention votes. These produce relatively less of the financial problem that this report documents. And then you get in through things like nonpartisan election, in which the parties often are not mediating forces, but have been in Ohio and Michigan, or straight partisan election, in which what you expect is that people will go out and raise money and run ads. And so as a state makes those decisions, and happily in 2012, most of them said we'd rather stay over on this end than push ourselves into the situation where there's a lot of money spent for relatively specific outcomes. And I think once you make the decision that that's where you want to go, it is very difficult for an election not to be an election, either because people will find a way to support the candidates that they like, or because they will expect that the candidates whom they elect do the things they elected them to do. That's sort of what elections are for. These other methods have a democratic element in them, but it's much more attenuated from the regular partisan politics that we think works for us in other parts of our government.
Can I follow up on something Alicia said? I think that a merit-based selection system would be greatly strengthened if the voters felt they had substantive information that would allow them to cast a vote based on competency and qualifications and ethical behavior and all of that kind of thing. And I'd like to suggest that anybody interested in that might take a look at the Colorado system, because they have done a marvelous job in creating a judicial performance a system of judicial performance evaluation that is made available, the results of which are made available to voters prior to the judicial election. I thought it was very difficult in Iowa to make the argument that retention elections were originally intended to allow voters to evaluate the competency of judges when the voters had so little information about judicial performance. There was a bar survey, which of course was dismissed by those opposing retention as well. Of course the lawyers are going to think they're great judges. They're part of the ruling elite. So you really need some objective, substantive system that supports the notion of a retention election vote being based on merit.
I think that a judicial election is a complicated thing on a good day. We're the only country that elects any significant number of judges, and it's in part because we come out of a populist tradition. We're a country that was born in a rebellion that created elections, and that's part of our fiber. And therefore, you can, as Justice Shepard said, you can spend your life and your career debating and have a good debate about the best way to pick judges for particular purposes and reasons, and yet I guess what I would emphasize is that very debate is no longer just kind of Aristotle and Alexander Hamilton. It's changing under our feet. The money is changing this entire debate. That's why we're all sort of calling for some version of rethinking, whether it's a small or a large step. With that said, let me ask, Lori, do we have any questions from the web that have come in?
We do have a couple of questions.
And I'm sorry, question over there. I'm sorry, I didn't see you.
Well, Justice Turnus has sort of preempted my comment. I'm Carl Cummins. I'm with the Coalition for Impartial Justice in Minnesota, and we are the advocates for judicial reform in the state. We have a well-established merit selection system already. We are seeking a constitutional amendment to allow for retention elections, but the third element of our effort is exactly what Justice Turnus pointed out, and that is creation of a nonpartisan judicial evaluation commission, which would evaluate judges' performance before their retention election takes place, make recommendations as to whether a judge should be retained or not retained, and provide educational materials to the public, which hopefully the press would pick up on, and educate voters more substantially than they are currently educated about who the good judges are and judges who may not stand the test of see they be retained or not.
Thank you very much. So actually, in fairness to our web viewers here, why don't we try to see if we can take one or two questions at least before we then turn back to the audience. So Lori's been gathering these from the web as people have been watching.
Right. First question, from a practical standpoint, how does one formulate a message to convince legislators in control of campaign finance reform think that such reforms are a good idea? It seems they now believe the lack of spending limits and lack of transparency benefit them. How does one change that perception?
This is the big question. And I think for the reasons we've been describing, it is a tough road to hoe right now. I guess in addition to all the things you could say about how to effectively talk about the role of money in politics generally, I would add something else that we've learned from our own polling over the years, that if you ask a generic question about money in politics or reform, and you get a certain answer, how many of you support public financing, let's say 50%. If you ask the exact same question about the same reform just involving the courts, you'll get an uptick in support for reforms. There's a band of people out there who believe they know that courts are different and they're supposed to be different. They perhaps deserve even more protection than the other branches. We have found that argument at times to be very useful and compelling for people.
I agree with Bert's answer, but I'll offer you up a little vignette that it turned out to be highly practical. There was a moment when there was some discussion about changing Indiana's system from merit back to election. I encountered the chairman of one of our political parties in the hallway of our state capitol building, and he and I started chatting about this, and I said, if I had to run a political campaign statewide for the office of Chief Justice, do you doubt that I could raise $1 million? He said, no, I don't doubt that you could raise $1 million. Where do you think that money would have gone if I hadn't directed it to my campaign? I said to him. He said, I get it. And the bill failed.
That was a rather...
It worked. It was a very convincing argument.
And it took about 30 seconds, right?
Yeah, he was way ahead of me.
Another question from the web.
Yeah.
This one comes from Mr. Brent Beckert, Senate Judiciary Committee staff. Are there any reforms possible at the federal level?
Well, I think one federal, one federal reform we could see would be, adjustments to disclosure requirements, for example, among some of the quote-unquote social welfare organizations that that are increasingly spending money not only in federal elections, but also, as we documented in our report, that kind of spending is now also trickling into state judicial races. And one of the challenges with those organizations is that they typically are not required to disclose donors, and so it's another example where we don't know where that money is coming from and who's actually trying to shape our courts and shape both the judges that are chosen to courts and the decisions that judges are making. To give just one example, we documented that Americans for Prosperity, which is more commonly, I think, thought of among, in terms of these in terms of national races, actually spent money both in North Carolina and in Florida. In North Carolina, they spent about $250,000, which they described as their largest expenditure to date in a judicial election, and it's a trend that we're expecting to continue going forward.
Alicia Bannon took the question one way. I took it a different way. I took it to mean, are there any things that could be improved about the selection of federal judicial officers? She may be right, but I'll answer the question in a different way. I'd say there too. When Joe Biden was chairman of the Judiciary Committee in the 1980s and early 90s, he was very emphatic that senators who were sending forward names form screening committees like the merit selection committees that exist in 35 states. That has the effect of producing candidates who enjoy more widespread support, particularly if the system is a public system. And that notion that he promoted as chairman of the Judiciary Committee has wandered off and is now not used nearly so often. In terms of confirmation, I think the only practical idea that's actually worked, and it only worked for a while, was an agreement by a group of senators that I think called themselves either the Gang of 12 or Gang of 14, can't remember how many, in which there was a pact among the group. We'll vote cloture, and we'll vote equal numbers of both parties. We'll vote cloture, and we'll meet to decide on all these nominations, and we promise each other that we'll vote to do that almost all the time, absent some dramatic problem with the nominee. There were enough of them that they were able to make it stick, that the rest of the Senate being equally divided, if the 12 or the 14 agreed to move forward, that the nomination would move forward. And it seemed to me an eminently practical and really maybe the only practical way, at least in the short run, of improving the confirmation system.
I think Randy's comment highlights the fundamental way these systems operate, and that is they only operate as well as the commitment of the individuals involved in them are to making them operate the way they were supposed to operate. So the reforms, I think, have to be in our culture, in the way we approach the appointment process or a retention election or selection of judges, whatever it is, so that we have a culture of making appointments promptly or being sure that we get the most qualified candidates into these positions. But until we're committed to doing that, I don't know what reform is going to force us to change our thinking. I think it's going to require a coalition of a lot of groups, the bar associations, the Chamber of Commerce, the League of Women Voters, you name it, together demanding that there be change in how some of these institutions operate.
So before we go to a final question or two here, I did want to mention that there's some new research that actually was also released yesterday that's relevant to some of the topics we've been discussing, and it has to do with the effect of all the money on criminal cases. We were talking about this earlier. And I don't know if anybody's here with the Center for American Progress, but they actually released a study yesterday indicating they had done research, and I'm going to very crudely paraphrase it. I encourage you to just go look at the study. I think they indicated some concerns they came out with about the idea that the escalation of money may be, in fact, be pressuring or intimidating judges to be even tougher as election time approaches. And it certainly would bear out research we've seen in at least a few states where we've seen situations where capital convictions, death penalties that were handed out by juries, were less likely to be overturned as election time approached. So anybody interested in this topic, I'd recommend you take a look at the website and with the Center for American Progress and see what they have as well. Let me just ask, is there, if not a final question in the room, perhaps, is there one from the web? Tom. So,
Nobody else has one?
microphone coming there.
Tom Gottschalk again. This one for Justice Shepard. I'm, Frank, as a member of the bar, frustrated by the continuing long debate over recusal for all the issues that are raised, as you highlighted in your remarks. What I'm wondering about is how you would feel about taking a good first step and postponing the resolution of all these other issues in terms of how far you take recusal, how to indirect contributors or whatever. It seems to me, given the poll, it says 87% of the people think that donations influence decisions. The simplest and cleanest recusal rule ought to be that for each state, where a litigant appears before the court, either lawyer or the client, the party, has made a contribution over X amount, that the opposing party has an automatic right to recuse that person. And all the dialogue from judges about, well, this could impair the efficiency of the courts and so on and so forth, ignores the fundamental fact that the average member of the public just believes necessarily that if the judge knows a person who's provided significant financial support for their job is appearing before them, he will tend to favor that person. So why can't the bar just take the fundamental step of saying a litigant or who comes before the court who's contributed X amount of money may lead to an automatic recusal on motion of the opposing party?
Our court debated this at some length the last time we did changes to our Code of Judicial Conduct. One of the things you have to do is make sure that rule can't be used for strategic purposes. I don't like Shepard. I'd rather have Turnus, so I'll contribute to Shepard in order to make that happen. So you have to somehow wire around. I would say most of the disqualification motions that I received as a judge were actually strategic in nature. They weren't questions raised that looked like worries about an association or something. They were people who were counting votes. And we've had a recent situation in our state where it's pretty clear that that was what was happening as well. So you and I might have a longer discussion about this. I'm skeptical that a straightforward solution of that sort gets us where we'd want to be.
Just to add to that, the Brennan Center put out a report proposing model rules for recusal reform, and we have a proposal that I think is responsive to that concern, that would allow the litigant on the other side to waive the recusal. So in other words, if if there were campaign contributions by an opposing party, that litigant could waive the judge's recusal and I think address, at least to a large extent, some of the strategic concerns that Justice Shepard is talking about. And another thing that we discuss in that report is having the parties themselves take on the onus of reporting the contributions or other spending that they've made, akin to corporate disclosure statements, which are widely used. I mean, that's one of the things that in the federal system is a requirement. When you file a case, you need to file a corporate disclosure statement about, so that a judge can understand whether or not they have a financial interest in any of the litigants that are appearing before them. And we think something similar could be done in the recusal context as well, around campaign spending.
Yeah, I think there are. I mean, one does. It seems to me can construct arrangements which work at each of these elements. One of the things you'd have to worry about with respect to waiving of disqualification is that the case doesn't just belong to Smith and Jones. It belongs to all of us. The damage done to the credibility of the system is, Smith and Jones think Shepard is fine. That doesn't mean the public thinks he is, and they're the long-term owners of the system. So it seems to me a highly complex matter in which the chances of doing harm are close enough to the chances of doing good, depending on which you choose, that I'm not surprised it's taken us a long time to work this out.
So, Justice Turnus, do you have a final word before we close here?
No, I think I've said everything I wanted to say.
That's not a very Washington answer, I want to just say. Let me just convey my extreme gratitude, and I think on behalf of the audience, for just a premium quality conversation here with some outstanding panelists. If there's a person in America who's not affected by the issues we've described today, I don't know who that is. If there's an issue that is a matter of public debate in the United States, it's not affected by what we're describing today, I don't know what that is either. And as part of our goal to really get more organizations, more people involved, having these kinds of discussions, having the most eminent people in the field come forward and talk, having people like Alicia and organizations like the Brennan Center be part of this is step one in the solution. So I just want to thank everybody. I want to thank all of you for coming. Thank those of you who joined us on the internet for your questions as well. These are conversations that we literally hope will continue both in the next few minutes and going forward. You have the information on our organizations. We'd love to talk more with you, and thank you very much for a terrific discussion.